good afternoon to all of you from all over the world who have joined us today. My name is Maria Thanasiou, and I'm one of the three co-chairs of Young ICA, together with my colleagues, Theominique Notage, Matthew Morans, Rahul Donde, and Ana Coimbra Trigo. It is my pleasure to welcome you to this webinar on emergency arbitration. Now, the purpose of today's session is to provide an introduction to the specifics and modalities of emergency arbitration, focusing on the considerations prior to filing an emergency arbitration request, the role of junior counsel in preparing such a request, and the perspective of an emergency arbitrator when dealing with the emergency arbitration request itself. Now, we hope that by the end of the session, you will have gained sufficient knowledge so that you can apply it in an assignment that you can complete with a group of up to 5 other webinar participants. We will award a certificate of attendance to all of the participants who complete the assignment in a satisfactory manner by August 11th. And in addition, we will award the group that submits the best assignment with a special prize involving each of our panelists themselves and their valuable time. So if you are interested in participating in this exercise and qualifying for certification and the prize, please stay tuned at the end of the webinar when we will explain the process for participation. We will also be posting a link on the chat box for those who are eager to register at the outset. Now, before we begin, I would just like to say a few words about Young ICA, which operates under the auspices of the International Council for Commercial Arbitration, with the mission of opening the doors of international arbitration for young practitioners and students. Young ICA is now over a decade old, and it includes close to 10,000 members from around the world, to whom we provide access to free of charge resources and programs in 40 areas. First, we coordinate, as you may know, the mentorship program, which connects small groups of Young ICA members with leading practitioners for a 2-year cycle. Applications for this program open up towards the middle of the summer each year, and they are available on the Young ICA website. And just to confirm, the application process for the upcoming cycle has just opened. Second, we provide access to 3 full tuition scholarships for graduate programs focused on dispute resolution in the US, in Switzerland, and in China. Each of the scholarship has its own opening and closing dates, and all the information about that is also available on our website. Third, we run the blog, which receives, edits, and publishes short articles on leading issues in international commercial arbitration. And selected articles on this blog are then republished by Kluwer Arbitration for maximum impact. And fourth, we organize a number of workshops throughout the year, like this one today, focusing on the development of practical skills which are critical to the practice of international dispute settlement. Now, for those who aren't familiar with our parent organization, the International Council for Commercial Arbitration, or ICA, it's a storied NGO which was formed 60 years ago to promote greater knowledge and understanding of international arbitration worldwide. And from its bureau at the Peace Palace in The Hague, ICA does this by taking on a number of important activities. Among them, it produces authoritative publications like the annual yearbook of commercial arbitration and a collection of country reports in the ICA handbook. It organizes a biennial congress, which is the largest regular event dedicated to international arbitration. And it facilitates training for judges on the application of the New York Convention. And finally, it operates a wide variety of projects tackling current issues in the field. So once you are ready to take the next steps in your career, we would encourage you to get involved, to become a member of the ICA community, and to help to contribute to this field that we all love so much. Now, having said all that, it's now time for the main event. We are very honored to have with us today a distinguished faculty, including an outstanding practitioner as our moderator, Mrs. Dilber de Vitre. A few words. Dilbert is an associate in Homburger's litigation and arbitration teams. Her practice focuses on international arbitration, both commercial and investment, and she has acted as counsel in complex and high-value commercial and investment arbitrations under several institutional arbitration rules. She's a member of several below 40 arbitration groups, a member of the steering committee of the Young MCIA, and admitted to practice law in France. She regularly speaks in English, French, and Hindi, and in 2021 she was named Rising Star in Arbitration Switzerland by Legal 500. She holds a master's in law from the University of Panthéon-Sorbonne and a diploma in international business law from Columbia University and Sciences Po in Paris. Now, Dilber, thank you so much for being with us today. The floor is yours.
Thank you so much, Maria. So it's really a pleasure to be here today with all of you. Thank you so much to Young ICA for this very kind invitation. It's my absolute honor to introduce today's panelists. I think you have a stellar panelist ahead of you, and there's probably nobody better than these three to explain emergency arbitration and what it's all about today. So without any further ado, I'm going to introduce our three panelists in the order in which they will be speaking. And the first one we have today is Victoria Kandri Milo. Victoria is a counsel at the Hong Kong International Arbitration Center, the HKIAC. Prior to joining HKIAC, she also has practiced in a leading law firm in Moscow. She's fluent in English and Russian. She also speaks Spanish. She graduated from the Moscow State Institute of International Relations, and she also has an LLM from the MIDS in Geneva. So Victoria, we're really, really happy to have you here today. And Victoria is going to be presenting to us the point of view of an institution and how institutions deal with emergency arbitration applications and how in particular the HKIAC deals with these applications. So she's the best person to give you this point of view today.
Thank you, Dilber. Thank you, Dilber, for your kind words, and good day to everyone.
Thank you, Victoria. After her, we'll have Elizabeth Chan, who will be speaking. Can I call you Lizzie, I hope? So Lizzie Chan, she's an associate at Three Crowns. She also specializes in international commercial arbitration and investment treaty arbitration. She represents both states and investors. She currently works in Hong Kong, but I think Lizzie's worked all over the world. She's been in London, New York, New Zealand, quite a few international arbitration centers. She's a board member of Arbitral Women. She's also a member of the Equal Representation in Arbitration Pledge, Young Practitioners Subcommittee. She teaches at LLM programs at LSE and Queen Mary University of London, and she holds an LLM from Yale University and an LLB from the University of Auckland. So we're also very, very, very privileged to have Lizzie speaking to us today. And Lizzie is going to be presenting the point of view of counsel and how counsel, and in particular young counsel, should address and deal with an emergency arbitration application if it comes up in their practice. And Lizzie, I think, has prepared 10 tips or points that she's going to share with you today on how best to prepare your emergency arbitration application. So thank you, Lizzie, for being with us today. And last but not the least, we have James Hosking. James has been practicing in international arbitration disputes for over 25 years. So you have someone here today who is very, very experienced in international arbitration, and particularly in emergency arbitrations, because he was the co-chair of the ICC Task Force on Emergency Arbitration Proceedings. So he's really one of the best placed people to talk about emergency arbitration today with you. He is recognized as a global elite thought leader by Who's Who Legal. He's only one of the 12 such lawyers in North America to have received this distinction. James is going to be speaking to us today from the point of view of an arbitrator, having actually sat as an emergency arbitrator and dealt with all the issues that we are going to be talking about today. James is going to bring his experience to the table and discuss how he has dealt with these emergency arbitration disputes. So really a very, very, very experienced panel. I hope you all are going to take away a lot from them. We're going to have a very interesting discussion. And having said that, I'm going to pass over the mic to Victoria.
Thank you very much for the invitation to speak today on the panel. And during my presentation, as Dilber already said, I will try to give the answer why and when to start the emergency arbitration, and will give also a brief outline of the emergency arbitration procedure from the institution perspective. And just as an introduction, I want to say that when we speak about the emergency arbitration, we speak mainly about the interim measures. And the purpose of the interim measures is to minimize the disadvantage to a party which may occur before the final resolution of the dispute and enforcement of the arbitral award. And traditionally, a party which needs the interim relief before the constitution of the arbitral tribunal would go to a state court. However, going to a state court could be unsatisfactory due to some points, for example, as the confidentiality issue, or for example, that might be costly and lead to some delays, or we can say that sometimes there is a perception of bias about the courts, especially when one of the parties and the proceedings are located in the same jurisdiction, or if the parties ultimately bargain in their contract for the arbitration agreement, they want to stay within the same framework, and therefore they don't want to go to the court for the interim relief prior to the constitution of the arbitral tribunal. And for that purpose, the emergency arbitration made the interim relief available to a party before the constitution of the tribunal. And HKSC rules, which are consistent with the international practice, they define the emergency relief as urgent, interim, or conservatory relief prior to the constitution of the arbitral tribunal. And in this respect, I would like to emphasize the point that we are talking about the urgent relief, and which is requested before the constitution of the tribunal. And to date, HKC has handled about 30 applications for the appointment of the emergency arbitrator since the introduction of such mechanism into the HKC administered arbitration rules in 2013. And this date is important because that means that if your agreement has been concluded before 1st November 2013, the emergency arbitration mechanism is not available to the parties unless the parties expressly agree to apply this mechanism. And the application for the emergency arbitrator can be done before filing the notice of the arbitration, concurrent with or following the filing of the notice of the arbitration. And the possibility to file the notice to file the emergency arbitration application before filing the notice of arbitration has been introduced on 1st November 2013. And if the party failed to file the notice of arbitration within 7 days after the application, the emergency arbitration will be terminated. And such consequence was introduced with the reason that it will deter the party from abusing the emergency arbitration procedure, by which a party can obtain a favorable relief at an early stage and without any serious intention to go further with a dispute on the merits. And the other requirement that is necessary in order to apply for the emergency arbitration is the payment of the deposit. Usually the deposit that the applicants needs to pay consists of two parts. The first part is the fees for the institution, the administrative fees, and the other part is the fees and expenses of the emergency arbitrator. In HKC, the amount of the deposit is 205,000 Hong Kong dollars, and that amount shall be paid together with the filing of the application. And besides these two requirements of timing when the application can be filed and the deposit, also the application shall comply with the rules in terms that it shall mention all the information that the rules requires. For example, HKC rules require that the application shall state the circumstances that gave rise to the application. As an example, I can give such circumstances. For example, we saw in the application that the applicant specified there was a dispute over the control of a joint venture, and the applicant specified that the respondent tried to withdraw the funds from the joint venture, and also some safe box was removed from the premises of the joint venture, and in that circumstances led the applicant to file the application for the emergency relief. And also the applicant shall state why the emergency relief is needed on the urgent basis. And when the HKC received an application and the deposit, HKC shall appoint the emergency arbitrator. And the emergency arbitrator cannot be part of the arbitral tribunal afterwards. So the mandate of the emergency arbitrator is temporary. And in addition, the emergency arbitrator is not empowered to order the emergency relief on ex parte basis. That's why when the applicant files its application with HKC, it shall prove that the application has been filed with the other party as well. And when as an institution check the application for the acceptance, we look at the manifest and obvious ground whether to accept application or not, and these grounds includes what I have just mentioned. And it's necessary to say that the final say will be for the arbitrator, for the emergency arbitrator, because he or she has the power to rule on the admissibility of the application and his or her own jurisdiction. And as I said, the urgency is the inherent nature of the emergency application, and this is led to the shortened timelines for the procedure. First, when HKC proceeds to the appointment of emergency arbitrator, we have 24 hours for doing so, and we calculated that in general for the application that we have already processed, we spend around on average 16 hours to appoint the arbitrator. Also, the arbitrator has a very short time limit to render his or her award, which is the 14 days. With respect to the procedure that applies after the appointment of emergency arbitrator, this here arbitrator is at the discretion how he or she wants to conduct the proceedings, whether it will be the document based only or whether the oral hearing is required. With respect to the interim relief that an arbitrator is entitled to grant, here is also a wide discretion for doing so, for example, it could be the order to preserve assets, evidence, status quo, or the order preventing the party from taking some actions. But it's necessary to mention that generally there are two exceptions to such scope of the interim relief, which are ex parte relief, and also the interim relief that will affect the rights of the third parties which are not the parties to the arbitration agreement. And if we look at the HKC practice and see what categories of dispute lead to the application of the emergency arbitrator, we can say that there are top three categories of disputes that the applicant, where the applicant search for urgent relief. First is the corporate disputes, second it's trade, sale of goods, and the third one is IP. I would like to give an example of the such application. For example, there was a dispute where a claimant invested in one of the respondents, and under the agreement, claimants were granted the put options, meaning that they, under certain events, they can sell back their shares to the original shareholders. And then after that, claimant witnessed that respondents were dissipating their assets to the connecting parties, and claimants requested the worldwide freezing injunction in relation to the assets of respondent up to X amount. And what the tribunal, what the emergency arbitrator is granted, it was the order that prevent the target company from entering into any unauthorized transaction which is not in line with the article of association, rather than freezing the assets of the company. And it's also interesting to note that for applications from 30 applications that we have handled so far. So 4 applications were resulted in the consent award or undertaking from the opposing party. And this is also remarkable because sometimes, if I can give such example, when the applicant asks the other party to refrain from convening any meeting of the board of directors for a certain period of time, and the other party, instead of litigating in the emergency arbitration proceedings, agreed to give an undertaking that any general meeting of the board of directors will be convened with the prior notice around X days beforehand, and with the agenda communicated to the other party. So this shows that such application can also be an incentive to the other party to agree on some compromise. With respect to the tests that the emergency arbitrator look when he or she grants the emergency relief, under HKC rules and most institutional rules, the only express test is the urgency, and that gives a wide discretion to emergency arbitrator to consider what the other standards and in light of the particular circumstances of the case. And it could be, for example, from the practice we see, it could be the standard of irreparable harm, the success, the reasonable opportunity of success on the merits, or the balance of harm. And at the end of my presentation, I will just just briefly speak about the form of the decision of the emergency arbitrator. So under HKSC rules, the form of the decision could be a decision, order, or an award, and it shall be signed by the emergency arbitrator and also to be in writing. As to the contents of the award, the award shall be reasoned and also contain the statement or the conclusion on whether the emergency arbitrator has the jurisdiction to consider the emergency application. I know that some rules prescribe mandatorily the emergency arbitrator to decide on the costs. That provision was of mandatory character in 2013 HKSC rules, and in 2018 version it's of discretionary nature, so the emergency arbitrator does not need to address the costs, and the costs will be addressed later by the arbitral tribunal. And my last point is the nature of the emergency arbitrator award, that under most, I think under all institutional rules, it provides that the award has a binding force on the parties, and it has a temporary character, meaning that it can be modified, suspended, or terminated by the emergency arbitrator and the arbitral tribunal. I think that all from my part, and I look forward to the questions. Thank you.
Thank you so much, Victoria, for this very global and comprehensive dive into emergency arbitration to start our seminar. I think we have a lot of questions. I have a lot of questions for you, and I've noted them down, but I think what we'll do is we'll go to the next speaker. We'll let Elizabeth and James make their presentations as well, and then we'll take all the questions together also from the audience. So with that being said, Elizabeth, over to you for your practical tips.
Well, thank you again to Young Ika and my fellow panelists and moderator for the opportunity to present today. So imagine that your client has decided to proceed with applying for an emergency arbitration based on the factors for and against that Victoria has just told you about. Now, as junior counsel, you play a really important role in making sure that that application is successful, in particular complying with all of the requirements and the payments and deadlines. So having spoken to my friends who are far more experienced than me, both at firms and at institutions, I've put together a list of 10 tips to think about. But probably the most important point that I want to leave you with today is to make haste slowly. And EA applications are a little bit different from some other written submissions because of the timing. And it can be very easy in these tight timeframes to say something outlandish or something potentially wrong. And that could be a problem later if you need to row back from something that you've said in the EA arbitration. And that's a problem because the submissions that you make during the EA application process will be part of the arbitration record as a whole. So what are these 10 tips that I've come up with? The first one is to check whether you need to apply for emergency arbitration at the same time as you file the request for arbitration. Now, to find that out, you need to look at the rules. So under some rules, for example, the HKIC and the ICC, you can file the emergency arbitration application before the RFA, but that's not possible under all rules. Now, there's a few strategic considerations here. First, if you can apply for the EA separately from the RFA, that gives you a little bit more time to prepare the RFA, although in practice, there can be quite a short time frame to follow up with your RFA. And under some rules, that's just 10 days. It can also be useful to delay the RFA because there might be some response from the other side in their response to the EA application that you can use to inform your RFA. Now, more practically, it's important to communicate with the institution. So my institutional friends have suggested, giving the institution a call hopefully at least 1 or 2 days before the arbitration, letting them know a little bit about the case, including the nationality of the parties and the seat, so that the institution can start to think about arbitrators who might be able to look at this case on an urgent basis. It can also be useful to apply for your EA application as early in the day as possible, because that gives the institution more time to find an arbitrator. It's also important to think about time differences. So for example, if you are making an application in a jurisdiction that is different, or a time zone that is different from your own, it can be difficult for an institution to proceed with finding you an arbitrator if you're not going to be awake and available to answer their questions. And as you heard from Victoria, they have, I think, 16 hours on average to find an arbitrator. So you do want to be as efficient as possible and be available to help the institution. My second tip, a boring thing, but a very important thing, which is to make sure you follow all of the filing and the payment requirements. So for example, check the institutional rules and other policies about whether you need to file hard copies and soft copies. There's been a little bit of change in this policy during the COVID-19 pandemic. So it's important to check the institutional rules. And also check who you need to file on. So check whether it's your responsibility as the applicant to file the EA application, or whether the institution will do that. Check any notice requirements in the underlying contract. And you might also need to check local service rules. And service is often important, as Victoria mentioned, because EA applications are generally not allowed ex parte, although some rules do allow for ex parte applications. Now, when it comes to the payment of money, quite often the institution will expect to have received the funds, or at least to have received confirmation that you have sent through the funds before they can start the process of finding an arbitrator. So, be aware of of any logistical requirements when you make payment. For example, if you're making an overseas transfer, you might need to leave a little bit more time to make that transfer of payment. And it's also very important to include evidence that you've made the payment, even if payment isn't going to arrive on the day that you filed the emergency arbitrator application. Alternatively, you can also consider making payment before you make the application, so that all of the administrative steps are in order before you apply for the EA application. My third tip is to make sure that you include all of the required information and the documents. Again, what's required will be contained in the institutional rules. It can be very useful to number your exhibits, number your paragraphs, and just make a checklist of all the things that you need to include, and also to include supporting evidence. The ICC actually has a very useful checklist with key elements that you should include in your submissions, and that an emergency arbitrator should consider including in their final order. So make sure you tick all those check boxes. Now, the problem with missing any information is that the institution will need to call you. They'll need to ask for supporting information before they can proceed with appointing an arbitrator. So some of the most common omissions will include failing to explain or failing to prove that the applicant and the respondent are signatories of the arbitration agreement or successors to the same. So you might have to include an explanation, for example, if there has been a change of name for a company, or if there has been a successor relationship, then it's useful to include also the supporting evidence, for example, an amendment to the contract or a novation. Also make sure that you check the applicable rules for any other information that you need to include. So for example, under the HKIAC rules, you also need to disclose certain details about any third-party funding arrangement. My fourth and fifth tips relate to admissibility, jurisdiction, and also substantive thresholds. I won't go into this in detail because Victoria has already explained it to you, and I think James will touch on this as well. One of my institutional colleagues suggested that a procedural order issued by the emergency arbitrator should request that the parties directly brief the tribunal on the applicable admissibility and jurisdictional standards, as well as any substantive standards, and also to address any disputed or agreed facts. Do make sure from an admissibility perspective that emergency arbitration is actually available. So Victoria mentioned earlier that you need to look at the start date for EA procedures and rules, and looking also at the date of the arbitration agreement. It's also helpful to look at the underlying contract to make sure that the parties haven't opted out of emergency arbitration. Victoria mentioned urgency as an admissibility threshold, and there are also jurisdictional issues to consider as well. And jurisdictional issues can arise, for example, where there is a multi-tiered dispute resolution clause, and there's a question about whether applying for emergency arbitration fails to comply with those pre-arbitration steps. There's actually a bunch of different jurisdictional issues that are addressed in the ICC task force report, which, as you know, James authored. The fifth tip relates to substantive standards for emergency arbitration, which Victoria has already mentioned, including urgency, balance of convenience, irreparable harm, etc. One thing to consider as well will be any local law standards that might potentially apply. Of course, an emergency arbitrator isn't bound by domestic laws, but they may feel that they get useful guidance from the same. My sixth tip, and the remaining relate to some strategic considerations to think about. So how many submissions will you need? I think James will go into more detail about what to consider during the case management conference, but there you can talk about the length, number, and scope of the written submissions. I saw in the ICC task force that typically there are 2 rounds of submissions in EA procedures, but of course, the more submissions you have, the longer the EA process is going to be, and the slower you're going to get your relief. My 7th tip relates to whether to include a witness statement. Typically, I think witness statements are not included unless it's really necessary. I mean, examples of where it might be necessary is where, for example, the interim relief asks state police not to harass a particular individual. So in that case, you might want a witness statement from an individual. But as I said at the very beginning of the arbitration, no witness statement that you submit now is going to be part of the arbitration record as a whole. And you might be in a bind because the witness statement might not be as comprehensive as it needs to be. And then later on, you find you might need to backtrack from something, or you might be tempted to put in a very long and comprehensive witness statement only to reveal something that's not going to be helpful for your case later on. And just given the short amount of time that you have to prepare the witness statement, think about the perils of including one. And of course, again, if you include a witness statement, then you might extend the timing of the EA procedure, and there might be a need or a request by the other side or the arbitrator for an oral hearing to cross-examine the witness. My eighth tip relates to whether there should be an oral hearing or on the papers. My understanding is that most EA procedures are decided on the papers. Again, if you have a hearing, it's going to increase time and costs, although I suppose nowadays we're much more comfortable with using virtual hearings. My 9th tip is a bunch of miscellaneous strategic factors to consider, which include, for example, whether you want to offer security or whether the emergency arbitrator requests one party to provide security for costs. You may consider checking for any enforceability issues before you request or apply for emergency relief. Although my understanding from the practice of EA procedures is that there's often voluntary compliance with awards. And even if there is a voluntary compliance, you might think about what you can offer as a respondent in terms of agreeing with, say, part of the requested relief. And if as the applicant, it's very important to you that there is enforcement, you might ask for the emergency arbitrator to issue a consent decision to at least encourage compliance. You might also consider as an applicant to apply for a preliminary order to preserve the status quo before the emergency arbitrator issues their order. This is pretty exceptional relief, and I think James is going to address that in more detail. And you might consider also whether you want to seek parallel relief from the courts. It might take a little bit longer, or it might be shorter, but you might maximize your success that way. Or at least put pressure on the other side and bring them to the negotiating table. Now, if you don't get the outcome that you want, as the applicant, you might consider if there are ways that there's any new evidence that might justify reapplying for emergency relief. Or if you're the respondent, you might consider ways to reduce the scope of the relief. And my final tip is to research relevant cases and to read all of the relevant sources. And there is a wealth of information out there. As already mentioned, there is James and the ICC Task Force's report on emergency arbitration in the history of the ICC. It's also very useful to look at previous cases in the relevant jurisdiction, digests, summaries of EA decisions, especially for their applicable rules. Also look at the ICC checklist, which includes all the things that you need to consider. It's also worth looking at the annual reports for the institution that you're applying for emergency relief under, because it might give you just an idea of how often emergency relief is successful, what tests are applied. And this data can be very useful in informing your strategy. So all of that said, 10 tips, things to remember are: make haste slowly, be aware of timing with filing your EA application and your request for arbitration. Make sure you check the filing rules and you make payment. Include all of the required information. Check for admissibility and jurisdiction and substantive standards. Check regarding the written submissions, witness statements, oral hearings, other strategic factors, and do your research. I hope that's helpful.
Thank you, Lizzie. That's very helpful, these practical tips. I'm really glad I have your written summary of this. I'm going to keep this in mind for my next emergency arbitration. Make haste slowly. That's an interesting oxymoron. And just a point, you mentioned one small detail which is so overlooked, and filing fees. It's something that it's so normal, you don't even think about it, nobody addresses it, but the delay that it can cause, and this happened to me in an emergency arbitration application, sometimes you don't even realize the delay that it can cause. You to take this into account so much in advance. I'm really happy you mentioned that as a very practical tip for our users here today.
And a quick follow-up on that, I've noticed in my work before, sometimes a client has asked the firm to provide an advance, for example, to pay for the fees. And so be aware of that as well.
Yeah. And there are sometimes internal processes within the client that could delay payment. So you have to take all of this into consideration. You may be ready to file tomorrow, but the client may not. So that's something you really have to keep in mind. So super, thank you so much for these practical tips. I think this will be very useful to all our listeners when they're doing the exercise that's going to follow up after this seminar. We'll move on to James now, who's going to give us a very, very interesting perspective from an emergency arbitrator's point of view. So James, we're very eager to hear what you have to say.
Well, thank you, Dilber, and hello, everyone. Thank you for your kind introduction, and hello from New Zealand, my home country, where I'm currently on vacation at the moment. What better thing to do on vacation than talk about emergency arbitrators? And as was mentioned in the introduction, I have the benefit of having sat a few times as an emergency arbitrator, and then also analyzed the first 80 ICC emergency arbitrator decisions, which are then analyzed in the ICC Task Force report. So I recommend that as further reading for anyone who is trying to learn up quickly on this topic. So Victoria and Lizzie have done a great job of giving you some tips from an institutional and a council perspective. I'm going to try and pick up on a few of those tips now from the emergency arbitrator point of view. And the primary one, and the one that I ask you to keep in mind at all points, is please spare a thought for the poor emergency arbitrator. He or she has taken on the task of producing an order in a very short space of time, somewhere between 5 and 14 days, depending on what institutional rules apply. And I think if you keep that in mind, you will be a much more successful counsel, whether you're the applicant or the respondent. This is a unique procedural tool. And so my primary suggestion is keep it simple. No matter which side you're on, you have a short space of time in which to try and make your case for the relief you're seeking, either for or against. So picking up on a few of the points that have been raised already, with respect to the application itself, there's no rules. When we looked at this from the ICC perspective, there's a vast array of different approaches. Often there are witness statements provided, but I would say, do you really need them? Because the more evidence you put in, the more potential there is for disputes as to the evidence, and the less likely the applicant is to receive their relief they're seeking. So really try and to carve your case down to the bare essentials as to what you require to get the relief you're seeking. Similarly, exhibits. I've received emergency arbitrator applications that have an enormous number of exhibits, and they're all very important for the full arbitration when it gets put before the full tribunal. But this is a very limited exercise. And so just the practicalities are, try and keep it to the most important, the most simple exhibits. Make sure your translations are appropriate, well done. Try and make the job for the emergency arbitrator as simple as possible. And from the opponent's perspective, similarly, keep it simple. If you look at the statistics, for example, from the ICC, less than half of emergency arbitrator applications are successful. So if you're a respondent, you should already feel good that the data's on your side. Do everything you can to try and convince the tribunal why the application should be rejected. And that usually requires a laser focus on what the particular test is. And Victoria emphasized the importance of urgency. The tests are all a little different depending on the institutional rules and applicable law, but at the heart of all of them is urgency. And you'll see from the task force report that that was the criterion most often used for denying relief. So really focus your opposition on that urgency aspect, and both as a admissibility question of the ICC rules and also on the substance of the application. Think about why is it the emergency arbitrator has to deal with this issue rather than the full tribunal with the full benefit of a full record. Also from the perspective of the opponent, more than half of the applications under the first 80 application of the ICC rules, there was a jurisdictional or admissibility issue raised. And they're tricky issues. As Lizzie said, spend some time up front as the applicant thinking about have I met all the tests? Have I put in all the information I need to put in? Can I preempt some issues that might be raised by the respondent? From the respondent's perspective, do you need to make the objection? Now that's going to differ in every case is different. You might have to for waiver reasons. You might want to do so to buy some time, but you might also think, do I really want to start off if I have a weak objection? If I want that to be the first thing that the emergency arbitrator is looking at, or if I feel strong on opposing the merits of the application, maybe it's better to proceed to that, but reserve my rights on jurisdiction or admissibility questions. And I also wanted to just point out something that's not obvious, which is if you are successful in your objection to admissibility or jurisdiction, or even if you're making the arguments, that can also be used against you in a parallel litigation proceeding where someone is trying to seek interim relief in the local courts. And there's some very interesting case law. I know that, particularly in the US, which I know best, on that issue exactly, where the emergency arbitrator proceedings are running in parallel with interim relief proceedings in the courts, and the pleadings end up in both sets of both fora, and judges, at least in the US, have a pretty short attention span for for those things. If you're saying, well, I can get relief in a different forum, I'll just send you over there. Or if there's no relief there, then okay, I'm in the right place here in court, and I'm gonna at least entertain your application. So think about what the ramifications may be of opposing jurisdiction. I wanted to pick up on something which is from the arbitrator's perspective, very, very important, and that's the case management conference. Again, spare a thought for the emergency arbitrator. You're presented with this file, you have the application, and you have to get out an order very quickly. Under some rules, there's actually a time frame, but under any common sense, you need to get an order out quickly as to how to manage the proceeding. Now, some applicants will actually propose what the first procedural timetable should look like. It's obviously just a proposal, it's up to the emergency arbitrator, but you might think about that and suggesting, for example, saying, this is not a case where witness evidence is necessary. We think that the case can be dealt with on the papers. If you're the applicant, you might try and make things as simple like that. For the arbitrator, it's difficult because you want to have that first case management conference. It may be the first time you've even heard from the respondent. And so what I typically do is I issue an order, which it has a date and time for the case management conference, and it has a detailed checklist. And the ICC checklist for the ultimate order that Lizzie mentioned is actually a very good starting point. But you might want to look at some of the other readings out there, like in the ICC task force report, about other things that you can include. So for example, I will try and deal with, is there a need for temporary interim relief to preserve the status quo pending the final resolution of the application? Sometimes the applicant raises that, sometimes they don't, but it's something that can be dealt with very effectively at the case management conference. From my experience, more often than not, if you're looking counsel in the eye on a Zoom call and saying, are you really saying you won't preserve the status quo until I issue my order? That's a more effective way than guessing how the parties will react and making some kind of preemptive interim relief order. But that does happen as well in some circumstances where ex parte relief is not available, but the arbitrator, if persuaded by the applicant, will say, for example, I'm going to issue a show cause order. So the respondent is prevented from doing X, or they should show good cause why they should not be prevented from doing X by 24 hours from receiving the order. Some way to get around the fact that you can't issue ex parte relief, but that puts a very tight time frame on the respondent's actions and requires them to react quickly. Another issue which Lizzie already touched on is the question of applicable standards, both with respect to admissibility and for the merits of the application. Again, I will try and get the parties to agree on what the applicable standards are in the case management conference. And if they can't agree, I will require that is briefed as an issue first up, so that the parties are at least fighting on the same playing field rather than just talking past each other. And with respect to those applicable standards, again, I commend you to the task force report. In around half the cases from the ICC, some transnational standard was adopted, like under the Section 17 preemptive interim relief, the preliminary interim relief standard under the UNSTRAL model law, or some other standards that you can find out there that have a transnational characteristic. In other cases, there'll be arguments made about doing a choice of law analysis and what the applicable standard should be that way, whether it's the seat or something else. But again, coming out of the case management conference, you want the parties to be either decided on that issue, or if they can't agree, then brief it up front. Moving on to a couple of comments on some things that have come up in the conversation so far that are sort of substantive issues. The first one I wanted to mention is urgency. Victoria mentioned it in her statement. That's really the core issue in all of these applications. And think about how you can prove urgency. Is there something that is what's your best argument on that, and put that at the front from the applicant's perspective. Secondly, hasn't really been touched on so much already, but focus on the relief. What is the specific relief that you're seeking? and keep that as simple as possible. The last thing an emergency arbitrator wants to order is some relief that is unclear or where it requires some ongoing monitoring by the emergency arbitrator until the tribunal is up and running. So think about what the relief is, and is it something that is practical for the emergency arbitrator to order? I had one case where that just, the parties were talking past each other on that issue. And ultimately, I just had to make a decision without any agreement as to, to pare down the relief to something that was actually manageable. A quick issue on a quick comment on parallel proceedings. It is frequently the case that there is a court action pending and the emergency arbitrator application is pending. That can come up in a couple of different ways. Often the emergency arbitrator application seeks an anti-suit or injunction, or asks that the respondent be enjoined from proceeding in court. So it's a hard argument to make. It has been successful sometimes in the past, but think about how that's going to play out when that's put before the judge in the court where the arbitration is pending, and that can be used against an applicant in those circumstances. I also wanted to quickly talk about enforcement language. As Lizzie said, very important to think about where your emergency order or award or decision, depending on where you are, is potentially going to be enforced, because there are nuances in the case law that are very important. In Italy, to summarize, forget about it. In the US, where there are probably more emergency arbitrator orders than the other jurisdiction, there's actually a very strong record of those orders being enforced as if they were awards, but there may be magic language that's required. So in the US, there is a requirement that the emergency arbitrator order be final, that it provides finality as to an issue. And if you have that sort of final language in the emergency relief that you're seeking, that makes it much more likely to be enforced. So think about it, brief it carefully, and make sure your arbitrator, who may be from a different jurisdiction, understands those nuances. A couple of final strategic points to pick up on. Lizzie gave you some great suggestions on things to think about. A couple more that occur to me. One is an unusually high number of emergency arbitrator applications lead to settlement of the entire dispute. Whether the application is successful or unsuccessful, the ICC statistics show that it's used as a sort of an opening, a shot across the bows in a dispute, which can bring the parties into a clearer understanding of the scope of the dispute and potentially cause a settlement. So bear that in mind as you're thinking about whether to bring your application and how to respond to it. How do I position myself best for getting the case to a settlement? The next thing I wanted to say, which again, Lizzie actually already covered, was beware of the record you create, because it can be used against you, either in a parallel proceeding, like I talked about, or in the arbitration later on before the full tribunal. And then that's the last point I'll make, picking up on that, is I have been arbitrator in at least 2 cases where I'm on the panel where there's already been an emergency arbitrator order issued. And I can assure you that's one of the first things that the panel will read, because it's often the arbitrator and you're interested to see how he or she dealt with the difficult issues that have been briefed to him or her. Now that creates obviously the new panel is not bound by the orders that were made by the emergency arbitrator, but they are influential. And there'll be a record there that you can read. If a party changes their position, that's going to be used against them. There are some tricky res judicata issues in some jurisdictions about positions taken in the preliminary emergency arbitrator phase versus later on. Think about that and be very conscious of it early on, because it can have a big impact on how the case ultimately plays out. And then as counsel, if you are trying to make sure that your emergency arbitrator order continues to be enforced before the new tribunal, think about how best to do that. Do I bring a new interim relief application? Or do I, as part of my request for arbitration or some other pleading, say, please just continue exactly as the emergency arbitrator ordered until we have a full chance to brief this? There's some interesting strategic questions there, and every case is different, but think about it strategically about what impact you think that order will have on the full tribunal. So with that, I'll leave my comments and pass it back to Dilba.
Thank you, James. I can see this issue, this topic has raised a lot of questions. We have a lot of questions going back and forth in our chat, and a lot of them have already been answered by our panelists. So I'm going to pick up on a few, and I have a lot of questions of my own as well to ask you. But I'm going to start with you, Victoria, because you gave us the point of view of the institution. And you explained that sometimes, the HKIAC has to address emergency arbitration applications within 16 hours. You have to appoint the arbitrator within 16 hours. How do you deal, or do you deal with conflict issues in this very, very limited time period? How do you consider this, or how does an institution deal with this when you have to react so fast? Independence, impartiality of the arbitrator.
Yeah, thank you, Dilber, for your question. I think what Lisa said before, we generally recommend to give a call to the institution beforehand. The applicant wants to submit the application for emergency arbitration in order to give some preliminary information on the nationality of the parties, on the seat of arbitration, and the applicable law to the underlying agreement. This gives us the idea of what the qualification of the emergency arbitrator should be, what nationalities shall be excluded, as there is a requirement that the emergency arbitrator cannot be a national of any of the parties. And but of course we check also the conflict on this dispute, because this is our regular procedure, and that's one of the most important consideration. We have the roster of the emergency arbitrators on our panel, and we submit the preliminary inquiry to a number of potential candidates with the subject of urgent and whether they can clear their conflict as soon as possible. Also, in the settings of pandemic, we always check whether the arbitrator has the stable internet connection in case the parties want to conduct a virtual hearing. And I think the best way to ensure this compliance with short time frame is getting the preliminary information on the core of the dispute in order to react quickly and check the conflict, the qualification, nationality, and the availability of the arbitrator.
Okay. So if I'm planning to introduce an emergency arbitration application to the HKIAC, I should give you a call and give you all this information.
Yes.
That's really interesting to know. Thank you so much. I think another question that's also come up in the chat, and it's something that I also wanted to ask James. Very interestingly, you mentioned that in the US, enforceability is possible if it has this title of a final award. But I thought one of the criteria of an emergency award was that it could be amended or cancelled or overturned by the tribunal later. So how do you reconcile the finality with the possibility of the tribunal to then rule over this award?
Well, you're much smarter than most US judges, clearly. So you're right. There's a intellectual tension there, but there's a strong US case law where that says that it doesn't matter what name you give a particular order or decision, whether it's an award or an order, the court will look at it as being within the Federal Arbitration Act if it is final as to the issues before the arbitrator. And courts have interpreted that as meaning if it is final as to the relief that is being sought before that emergency arbitrator. So that's the way that the courts resolve that particular tension. Now, it does differ from circuit to circuit within the US, but there's pretty strong case law on that. So if you frame your relief in a way that makes it sound as it is final as to that particular issue before the emergency arbitrator, then that's probably going to be enough to get it enforced.
Okay, that's very interesting. That's very interesting. Lizzie, amongst all the tips that you've given us today on emergency arbitration and how to effectively draft an application, in your view, what is a reasonable length of an application? We don't want to keep it too short, we don't want to keep it too long, but what would you recommend that our listeners, when they draft an application, how long should they aim that the application should be?
As short as possible, but including all the necessary information you need. It's a difficult balance. It's the same difficulty that we have with requests for arbitration as well. Ballpark, I think maybe like 10 to 20, maybe 30 pages, but really not more than that. James might have a view on this as well.
Yeah, sorry, go ahead, James.
I don't, and so it depends on the case. I try and get the parties to agree, and if they won't agree, then I'll impose something like 25 or 30 pages.
Okay.
Double spaced.
Okay. I mean, it's hard because it's the first time the arbitrator is even hearing about the case. You still have to explain the facts, but you still have to be succinct and put it into it's a hard call. Okay. I think we have time for one more question. There are a couple on the chat here. The role of national law. Somebody's asked Elizabeth based on Elizabeth's presentation. The emergency arbitrator may refer to national law for guidance. Now, would it be admissible, or can the emergency arbitrator order be rendered in the event that the arbitration seat is not yet known? That's an interesting question. We don't yet have an arbitration seat. I assume the parties haven't decided this in the arbitration agreement.
Yeah, in practice, I think the question of the seat might be resolved by reference to the arbitral rule. So I think, for example, under the HKIC, I think Victoria is nodding. So if in the absence of a choice, Hong Kong will be the default arbitration seat. But generally speaking, if you refer to research, national law research, you should be able to include those cases in your submissions.
Okay. Okay. I think a lot of the questions here have been answered. One question again to James and maybe Elizabeth as well, because you both mentioned this, and this is something that I have also experienced in my practice. Status quo orders, when you set out, when you launch an emergency arbitration, how often have you encountered them? And maybe this is for you, James. Are you more likely than not to order them because you know that they're for such a limited period of time and you don't want anything to happen in that time period that could then jeopardize, say, even the emergency arbitration order or the final award by the arbitral tribunal? So are you more likely than not as an emergency arbitrator to award status quo if a party asks you for it?
Yeah, so I guess if the applicant requests an order and that it be granted immediately, then that's obviously different from something I'll just raise as part of the case management conference. But like my usual approach then would be, at least under the ICC rules, there cannot be an ex parte order. So what I will say is that I am ordering that the respondent do X or refrain from doing X until Y date, which is usually the case management conference, or if we haven't got a date that we've been able to get quickly, then by a date before the case management conference, but where they have to file a reason as to why the order should not continue from that date forward. So the key point there is giving the respondent a fair opportunity to respond and limiting that by time as much as possible.
Okay. So you sorry, go ahead.
Oh, sorry. The only thing I would add is I think SEAC may be the only rules that expressly provide for preliminary orders. So then there will be a question for the emergency arbitrator about, in the absence of any reference or preliminary order, whether they feel like they consider they have the jurisdiction to issue it.
I just have to say, and I have to call Lizzie as a fellow New Zealander, there's a couple of other institutions, including Ammons in New Zealand, that do provide for it. But it's used, my understanding is very rarely. So it has to be extenuating circumstances.
Mea culpa.
Yeah. Yeah. Okay, interesting. And so this was sort of the life period or lifetime of a preliminary order, but what is the general life period or lifetime of an emergency arbitration order? How long does it last? What happens if the tribunal is not constituted later? Do you always include that in your order, the length of that order, how long it is applicable, or do you refer to the applicable rules? I guess this is for James.
Yeah, so I think I'm trying to remember now. I think there is standard. Well, I'm trying to think from my ICDR and ICC experience. I think there's either standard language that's proposed by the institution, but it's basically, and I don't know the IHKIC, but I'd be surprised if it was different. That it shall be in place until such time as the full tribunal orders otherwise, or language to that effect. I mean, there are some cases I'm aware of where the emergency arbitrator order remained in effect for a very long period of time because there were issues with the constitution of the merits tribunal, and so there are emergency arbitrators who have been required to remain, on call for ongoing issues for months at a time. There's at least one ISDS case like that I'm aware of. So yeah, there's this, I think, standard language that's typically used, and the emergency arbitrator and the institution have the same interest of trying to get these issues pushed to the full tribunal as quickly as possible. It doesn't always happen.
Victoria, how would the HKIC deal with this if the tribunal is ultimately not constituted, or there's delay in constituting the tribunal after an emergency arbitration award?
I think the question is in the nature of the emergency arbitration procedure, as it's adjacent to the main proceedings, meaning, for example, that under HKC rules that if within 90 days after the emergency arbitrator renders its decision, the arbitral tribunal is not constituted, so meaning that the emergency decision is not enforced after that date. So meaning that the emergency arbitration is not standalone procedure that will continue irrespective whether the main proceedings start being ongoing or not.
Okay, yeah, that's really interesting. I think that's all we have time for today. Unfortunately, we've run out of time. As always, I have a whole list of questions here, but I don't think I'm going to have the time to ask them to all of you. But thank you so much to all three of you for your very interesting perspectives on this question. For me, it was really interesting to see the different views of an institution, counsel, and arbitrator. Very practical advice from all of you. So thank you so much for your time. Thank you to Young ICA for organizing this. And with that, I'll hand over to Rahul Donde for the final vote of thanks.
Thank you very much, Debar, for your excellent moderation. Thank you also to the speakers for their excellent participation and excellent presentations. It's a very rich discussion. There's many different perspectives to look at this issue from. There's also, as we've already seen, a wide variety of institutional rules that address this issue from different perspectives. So I think the speakers really deserve a special round of thanks for covering such a dense topic in such a clear fashion in such a short time. So my appreciation, and on behalf of Young ICA as well as ICA, we thank all of the speakers and the moderator today for their presentations. We also thank the participants for their careful attendance and for listening. I should mention that we will be having a post-event report that will be published on the Young ICA website. So for all of you that were furiously taking notes while Lizzie was giving her top 10 tips, you'll be able to read them through the Young ICA report that will be published on the Young ICA website in the next few weeks. An audio and video recording of this webinar will also be posted on the same Young ICA page, so you can have reference to it in the next couple of weeks. So that, again, with a strong vote of thanks to all of you for your excellent work, that brings an end to the first part of our association, let's say today, which is the webinar. And we now move to the second part, which is the practical exercise or the workshop part of the event. Now, this event, Maria has already, or this part Maria has already explained in her opening, involves a practical exercise where we will ask you, the participants, to prepare a request for the appointment of an emergency arbitrator under the HKIAC rules. We will do this in a separate Zoom session. So you will find the link to that separate Zoom session already in the chat box and has been recently posted again in the chat box. What I would suggest you to do is to click on that link that will take you to a registration page. We will ask you to fill in a few registration details, your name, address, your name, contact details, etc. And we will then we will start that meeting and we will give you further instructions about how to orient yourselves for that practical exercise once we start that separate meeting. I should mention that we have a very healthy participation today, and there is a limitation on the number of people that we can admit for the practical exercise. So we will work on that on a first come, first served basis. I will give you further instructions on the practical exercise in that separate meeting. But for now, for the participants that are interested in the practical exercise, I would encourage all of you to please click on the link, which you will find in the chat box, enter in your details, and we will start that meeting shortly. It may take us about 5 or 10 minutes to do so, so please be patient. For the speakers, feel free to join that meeting if you would like to. But if not, again, thank you very much, and we look forward to interacting with you and having your closer association with Young ICA in the future. Thank you very much.
Thank you.
Thank you.
Thank you.